Hello, this is Steve Wilkes at the Wagner Law Group. Welcome to our webinar on private placements and some of the considerations that broker-dealers should bear in mind when they are distributing private placement investments. The reason we're picking this topic today is because we're seeing, at least among our broker-dealer client base, a lot of increased activity and interest in private placements. For some of you in the audience, this might be the first time you are considering adding this to your array of products. For others, you might have been doing this for a while, and maybe there'll be some good reminders here or some reinforcement of things that you're working on. So we hope it's helpful for you. I think our focus is going to be on due diligence for the most part, but there's a lot of things to think about with regard to a private placement and what broker-dealers are doing. Private placements are really used quite often as a means of raising capital. People are staying private longer before going public because private capital is just more accessible now. It gives issuers a chance to, maybe get their act together, clean up a little bit before an IPO, clean up the balance sheet, bring in some strategic players or validate particular interest from a particular sector, so on and so forth. And, IPOs aren't always a hot market. IPOs go up and down, and sometimes you're almost forced to look at a private placement. But private placement activity has been very heavy for a number of years, and there are a lot of exemptions as well. We'll talk about those a little later, Reg D and Reg A and so on. Some of our most recent data in 2018, I believe, the SEC's Division of Economic and Risk Analysis put out a study examining the use of private placements, and the study showed that in 2017, the funds raised in the private placement market totaled over $3 trillion, clearly outpacing the capital that was formed through registered securities offerings, which is about half as much. Like I said, this has been going on for quite a while, so the private placement market has always been very active. There are lots of exemptions, and it implies a lot of things for a broker-dealer firm to be thinking about. So I think one of the first questions one might ask is, again, for some of you this is new, others have already been in this marketplace. What would a broker-dealer do in the private placement market? What kind of roles do they undertake? Well, clearly they're executing a transaction and placing the security, they're selling it, but so they're introducing managers to investors and they're targeting investors. Some broker-dealer firms might specialize in a certain industry or kind of investment. Others might be more generalists. One way or the other, whether you're dealing directly with your own clients or part of a syndicate of placement agents, you're somehow going to be involved with marketing, and there are going to be a lot of documents to work with, including the private placement memo, fact sheets, communications, some advertising. You might also be involved maybe in entity formation. You might actually be involved with, partnership versus LLC, that kind of thing. And you also might be helping the issuer figure out how much to raise, what kind of strategy you're going to have in terms of a capital raise and what have you. So you play a lot of formal and informal roles, I believe. You might be negotiating a little bit some of the terms of the deal. So broker-dealers of all different sizes play these roles, large and small. And, there's an opportunity, for everyone, to get involved. What's the framework, so to speak, for this? Well, the securities laws require that, all offers and sales of securities be either registered with the SEC under the 33 Act or exempted, relying on an exemption. So when you're raising capital through the sale of securities in the market known as a public offering, securities, are registered. And, you register the offer and the sale with the SEC, which is a pretty extensive process, a lot of information, a lot of documents, unless there's an exemption available. And, in the alternative, the company can raise capital by accessing, the private capital markets through an unregistered private offering. And in general, I would say that the private market, maybe it's a lesser regulatory burden. The cost might be a little lower. It could really help smaller companies. But investor protection provisions, such as investor restrictions or limits, must be met in order to qualify the exemption from registration with the SEC. So there's a lot to think about in private placements. Let me point out just a couple of things for you. I mean, there's some state law considerations. Whatever you're doing, regardless of the SEC and FINRA, depending on where you are, there might be some state law considerations that come into play, blue sky and otherwise. There are going to be some Exchange Act considerations that the issuer needs to be aware of in terms of the size of the offering and what have you. There are also going to be one of the things that sometimes we see not handled properly are the proper needs for escrow accounts. Sometimes people don't escrow the funds properly during the raise, and some of those rules vary, depending on whether it's best efforts or kind of a firm commitment from the broker-dealer, but there's some different rules that apply. The Exchange Act requirements, refer to this as either all or none or part or none type offerings. And the all or none or part or none compared to best efforts have different rules about, funds, if funds are going to be returned to the investors if you don't reach the raise, and how they're held in escrow and so on. So that's something that you need to really keep track of. And those are in Exchange Act 10b9 and 15c2-4. Those are just a few of some of the things that you need to be mindful of. I would also say if you stop and think about it, just on the FINRA side, the FINRA aspects of private placements, can be pretty extensive. There are two key FINRA rules that might apply to certain offering documents and information about the issuer and the offering terms. FINRA Rule 5122, this is for member private offerings, requires firms that offer or sell their own securities or those of a control entity to file with, the corporate financing department, a private placement memo and a term sheet and so on. Then there's also Rule 5123, private placements of securities generally, that requires firms to file with FINRA's financing department, within 15 days after the date of sale, certain documents. And you also have to file, certain amendments or exhibits. There are rules on due diligence and suitability that we're going to talk about quite a bit later. Those are very, very important. They're really cornerstone to, I think, offering a private placement memo. The due diligence. Is this a security that I would sell to anyone? Is it worth being on my platform? And then more specifically, is it appropriate to sell to a particular investor? You have to think a lot about registration. Is this security exempt? You're going to be relying on the issuer's counsel, and maybe some of your own due diligence, depending on the facts and circumstances. Reg D and we'll talk about this in a few minutes. Reg D are the most popular exemptions. You have Rule 504, where you can sell up to a certain amount up to accredited investors within 12 months. There's a 505 has another limit, up to 35 unaccredited investors. And 506, also, of Rule 506 of Reg D, which we'll talk about, is another variation on the exemptions, and this is one that allows certain solicitations and advertising. So you have to really be aware of the kind of exemption path that the issuer is following and be comfortable. It's incumbent upon you to do the due diligence, to be satisfied that the exemption has been met, I think. Private placements, there's so many rules here. You have to think about the suitability. 51, 22, and 23, as I mentioned before, special rules for private placements. The different exemptions under Reg D. You have to kind of think of, the exemption in 4.2 for non-private, non-public offerings. What exactly is a transaction by an issuer that doesn't involve a public offering? What does that mean exactly? There's some intrastate rules, offering rules in Rule 147 for purposes of Section 3A11. There's restrictions on resales, Rule 144 and 144A that you need to think about. Reg S, applies to certain offers and sales made outside of the United States. There's some other FINRA rules and underwriting terms and conditions. There's the general 10b9 prohibitions on certain representations that you can make in an offering. And just, the 33 Act itself, just looking at the statute, 4A2. So there's a lot of material to cover, from a FINRA perspective. The FINRA has put out a lot of information on private placement. Some of it is more direct than others, but it all kind of ties together. Regulatory Notice 17-17 relates to some of the filing requirements on FINRA Rules 51, 22, and 23. Notice 17-14, just general, requesting comments on capital formation. Regulatory Notice 16-08, private placement subject to a contingency. That involves public offerings also. Regulatory Notice 13-26, Regulatory Notice 12-40, seeking comments. We're going to talk later about Regulatory Notice 10-22, where the FINRA gives some guidance on the duty of broker-dealers to conduct reasonable investigations, to really conduct some reasonable due diligence, and so on and so forth. So there's a lot out there from FINRA in terms of, formal guidance. And the best, in terms of recent interpretive letters, back in 2013, there was a letter to Trustmont Financial Group where they gave some guidance on suitability, and they talked about the duty to conduct due diligence both on a reasonable basis and a customer-specific basis. Meaning, on a reasonable basis obligation, this broker-dealer had to perform reasonable diligence to understand the nature of the security and the strategy, its risk and rewards, and then determine whether there's a reasonable basis to believe the security is suitable for at least some investors. And then you also, this reasonable basis obligation, as it relates to private offerings, gets really developed a lot more fully in Reg Notice 10-22. And then customer-specific, is just coming out of the suitability rules under 2111. It has to be suitable for a particular customer based on that customer's profile. So there's some discussion there on due diligence, both at kind of the macro level, looking at the security as a whole, and suitability for the individual. There's also, FINRA has also put out an excellent FAQ on private placements. It's on their website, where they have a whole bunch of information about filing requirements and disclosures and filing forms and what have you, with a really good Q&A. So there's a lot of material out there from FINRA on this in terms of some published guidance, which has been pretty helpful. Now, again, so just to frame it, we know that the law requires that offers and sales securities be either registered or exempted. And then in the public market, there's a certain route you follow. And in the private market, you can raise capital by accessing private capital through an unregistered offering. This might reduce, certain regulatory obligations. Maybe the costs are lower. In fact, they usually are. And this is really helpful for smaller companies. Like I said, investor protections have to be met in order to get the exemption. So just quickly, let's just talk about a few of the exemptions that are available. I'm not going to go into heavy detail on each of the exemptions. That could be a webinar of its own, but just to give you an example. So, we have, Section 4A2. And this is really a transactional exemption. It's the most utilized, and it's basically the application of the private placement, meaning that it's not a public offering. And what this means has been defined by the case law and by the SEC, and, there's some other safe harbors as well. And please remember that securities sold here are restricted. They can't be resold unless they're registered or otherwise exempt. And I guess the seminal case here was, the SEC against Rolstein-Purina, who was a Supreme Court case. And this is where they provided some of the guidance about, offers and sales to a large number and of employees, and whether or not this would be exempt or private or not. So, I think they kind of concluded here that the offering amount was unlimited. It could be any issuer. It could be any investor, really. No particular cap. They kind of set out some of the parameters of what a non-public offering might be. But even so, you never know for sure. So Regulation D, where a lot of people are very familiar with the activity we have there. Reg D is where you really get a pretty good safe harbor, if you will. And under Reg D, there are a number of exemptions that are available, and they typically fall out under Rule 504 or 506. But in either event, you don't have to register your securities. You just file what they call a Form D, and you have to also check with obviously with your state securities regulator to see where you stand. But Rule 504 basically says that you can offer and sell up to $5 million in any 12-month period, and except in limited circumstances, purchases. These are restricted, meaning that they can't be sold for at least 6 months or a year after without registering them. So that's one path forward. Then many people are really a lot more familiar with Rule 506, a safe harbor, if you will, where you can be assured that you met the 4A2 exemption. And under 506B, there's some requirements. There's no solicitation or advertising, unlimited number of accredited investors, and up to 35 other purchasers. Companies kind of decide what the information is that they're going to give out. This is where private placement memos and other documents are so important. And under 506C, which was a new twist a few years ago, a company can solicit and advertise a little bit, provided that everyone's an accredited investor and they take reasonable steps to verify the accreditation of the investors. And there are certain, sets of, restrictions that apply to those rules as well. And there are also there's some other exemptions available, Regulation A and crowdfunding. There's some special rules under 147 and 147A for intrastate. There's some special rules regarding, when you can, resell restricted securities. We're not going to go into all of those today. Reg S is, foreign investors, but so there are various ways forward by which one can get an exemption. The most common are the Reg D, so we'll kind of think about those a little bit in terms of our due diligence discussions today. But just remember that there are a lot of ways forward, and you really need to be conversant as the broker-dealer. You need to be comfortable that the issuer has taken the right steps to properly frame the offering, for the exemption. I have another slide or two here. There's some more information. So I think one thing also that we want to just remember is that even though you meet, in addition to meeting these exemptions, there's some liabilities that come with it, and Reg D transactions might be exempt from registration, but they're not exempt clearly from the anti-fraud provisions of the federal security laws. So this is where a broker-dealer has to start thinking about, the duty to have a reasonable investigation of the issuer and the offering and to conduct due diligence. Because even though the security is exempt, there's still other potential traps that the broker-dealer and the issuer are going to have to face. So let's talk just a little bit about liability, kind of the basis of liability. And I think this comes in a few different places. We have sections 11 and 12 of the Securities Act. We have some anti-fraud considerations, and there's a court case that I'll mention in an old not an old, but still a very valuable NASD report that was done back in 1981. It's fabulous to read. It's really incredible. It goes into incredibly detailed discussion on due diligence in terms of the law, due diligence best practices, legal liabilities, all kinds of things. Of course, this NASD report was more focused on public offerings than it was on private placement, but they do mention both. So I think the thing that I would say here, just to kind of start with, is that at least with regard to public offerings, and this becomes a benchmark for private offerings as well, there are some statutes out there. We have Section 11 of the 33 Act, which imposes liability on the issuer for material misrepresentation or omission in a statement. The issuer doesn't necessarily have a lot of defenses, but clearly there is a responsibility for due diligence. In other words, a reasonable investigation resulting in reasonable grounds to believe in an actual state of mind in which the underwriter does believe that the registration statement was correct. comes out of that kind of stuff that language, if you will, that concept comes out of the NASD report. There's also Section 12 of the Securities Act, which gives buyers a remedy for material misstatements or omissions by, any seller. Section 15 relates to persons who control a person who's liable under Section 11 or 12. Then you have, 10b-5 of the Exchange Act and 10b of the Exchange Act, I should say, and SEC Rule 10b-5, which is kind of the anti-fraud provisions, preventing the use of manipulative or deceptive devices. And then you have some other rules in the Exchange Act. So clearly, when you look at the prongs that might trigger, liability for misstatements or omissions or fraud or what have you, clearly undertaking a due diligence review of the issuer is really, really important. And they kind of baked into this is a standard of reasonableness, meaning, Section 11C says that in determining what constitutes a reasonable investigation, the standard of reasonableness shall be that of a prudent man to the management of his own property. And as FINRA, as the NASD said, they called it the standard of the street, meaning that they were looking at underwriters at the time. They said when an underwriter has conducted an investigation, one must realize that the standard of reasonableness is not an absolute standard that never changes. It depends to some extent on what constitutes commonly accepted commercial practice, kind of a prudent man standard. They called it standard of the street. So you really have to be aware of what other people are doing. So when you go back to some of the statutory language in the Securities Act and some of the old reports from the NASD, then you can see that that's where the concept of liability is established. Now, the Barr case, the Barr-Chris case was very interesting. It was a case. It's kind of the seminal case on due diligence and investigations and things. It was decided back in '68, but it still is valid, we think. And it kind of shows some of the law and some of the practical lessons of due diligence. It involved a public offering of debentures by a builder of bowling alleys. And, at the time of the closing of the offering, Barr-Chris, I think they were like the largest bowling alley operators and builders in the country. They were experiencing they were in a downturn. They were having severe financial difficulties. And this, of course, was not disclosed in any prospectus or registration statement or communication. The lead underwriter of the underwriting group had conducted a review of the disclosure documents and financials and everything, and they interviewed management, which it turns out supplied some false information. The underwriter also relied heavily on its law firm, whose work in this matter was performed by a very junior associate. And the courts basically said, in essence, that there had been an inadequate review performed. And they said here that the purpose of due diligence is to protect investors. So to that end, the underwriters, and one would think by extension, a placement, someone handling a private placement, a broker dealer, they're made responsible for the truth of the prospectus, or private placement world, that would be a PPM. If they may escape that responsibility by taking at face value representations made to them by the company's management, then the inclusion of underwriters among those liable affords the investors no additional protection. In order to make the underwriters' participation of any value, the underwriters must make some reasonable attempt to verify the data. They cannot rely solely on the company's officers or on the company's counsel. A prudent man in the management of his own property wouldn't rely on them. So here, in evaluating the standard of care, the court's saying that the standard, might vary, they went on to say it might vary depending on the person's responsibilities and access to information. For example, the court imposed a higher standard of care on a director who was also a partner of the company's outside law firm, stating that, as they said, as the director most directly concerned with writing the registration statement and assuring its accuracy, more is required of him by way of investigation than could fairly be expected of a director who had no connection with this work. So the court really rejected the defense that the underwriters, just relied in good faith on counsel and on the issuer, and that they had asked the right questions and felt it was okay. They said the counsel had been an agent of the underwriters, and that the underwriters, as principals, were responsible for the actions of the agent. So there's a lot of criteria in that case. It's a really, really helpful case to read about some of the do's and don'ts of due diligence. Now, I referred earlier to the NASD due diligence report. This is really a great document as well, and it should be in every compliant shelf library. It was actually, it was a report back in 1980 or 81, the NASD, FINRA's predecessor, did a series of seminars around the country. And they brought together a team of some really, well-known, high-powered, attorneys and compliance officers. And they just put on some fantastic presentations. And the report they issued, it's like reading a little mini treatise. It's very, very good. They talked about the liability, the potential liability. Now, remember, at the time, they were a little more focused on public offerings than on private placements. They do talk about private placements in the report. But they talk about the liability provisions of Section 11 and 12 of the Securities Act and the Barcris case. And they kind of came out with general principles to follow in conducting due diligence, including the need to perform due diligence for every offering, meaning you can never get so familiar with the issuer that you give it a pass. The necessity to customize the investigation for each offering, every deal is different. The need to identify high-risk areas, and the importance of maintaining detailed documentation, which we can talk a little bit. I think there's some pros and cons to that. And they also outline some specific terms to investigate. So a lot of these conclusions foreshadowed, I think, the reasonable investigation requirements that came out in FINRA Regulatory Notice 10-22, which really gets to the heart of the matter for us, because this is really there are no FINRA rules per se on due diligence of a private placement memo. There's been a lot of guidance from FINRA. There's been a lot of special reports on, hedge funds and variable annuity products and structured complex products and working with the elderly, senior citizens, what have you. This Regulatory Notice 10-22 came out in 2010. It was called Obligation of Broker-Dealers to Conduct Reasonable Investigations in a Reg D Offering. And it provides guidance with respect to a FINRA member's obligation to conduct a reasonable investigation. And they said that the investigation must be made of both the issuer and the securities offered. They go on to, there's a lot of material in there. They go on to state that a broker-dealer that recommends a security, just to have it on the platform, you have a duty to conduct a reasonable investigation concerning the security and the issuer's representations about it. And it talks about the broker-dealer's duty as one that emanates from the broker-dealer's special relationship to the customer, from the fact that in recommending the security, the broker-dealer is representing to the customer that a reasonable investigation has been made and that its recommendation rests on the conclusions based on such investigation. And again, they also were quite clear that a broker-dealer must conduct a reasonable investigation with respect to each offering, notwithstanding that the same issuer had previous offerings. I think a lot of times people are comfortable, private, agents, they find a good issuer, a good deal manufacturer, and they kind of get more comfortable. They get into deal 3, 4, 5, 6, 7, and you might slack up a little bit. And I think that's kind of a red flag. I think you need to go back to ground zero every time and be as diligent as you can be. So kind of in a general overview sense, I have a couple more slides here that I put together that you can look at that we'll talk about a little bit. But I would say generally, the whole purpose of this notice was to provide guidance and instruct broker-dealers on what they need to do. They're pretty clear. They point out that even though, Reg D, for example, might give you an exemption from the registration requirements, they clearly emphasize that Reg D offerings are not exempt from anti-fraud provisions, including 10b-5 of the securities laws, and that the broker-dealer, under judicial interpretation and SEC interpretation and FINRA interpretation, have a duty when they're handling a private placement to conduct a reasonable investigation of the securities and what the issuer says about them. and they go out of their way to remind the broker-dealers that, the courts have long held this duty to conduct a reasonable investigation. The main case, by the way, is Hanley versus the SEC, Hanly. It's a great case to read. This comes from the special relationship we talked about. And they say that, that the scope of investigation, depends on the facts and circumstances. Factors that you might consider, include the nature of the recommendation, what role is the broker-dealer playing, what does it know about the issuer, the size of the issuer, the level of sophistication of the investor, is it an institutional investor or retail investor or accredited investor. And they remind the broker-dealer that not only must you conduct due diligence, but you've also got advertising and supervisory rules to think about when you're doing this, and you, of course, have the specific suitability rules when you're recommending the investment to an investor. And they kind of talk about I think so. The due diligence here, I think, kind of goes back and forth a little bit. I think there's a due diligence of the security itself. This might be what you call reasonable basis suitability. And this means that you've investigated the issuer and the deal, and you have some rational, reasonable basis to think, based on your recommendation, that this is an investment that's worth carrying on your platform. It's worth recommending to someone. You're not sure who that someone is, but it has enough bona fides it could stand on its own merits. And then, the second prong, if you will, is more customer specific. And this is when you get down individualized, suitability, for a particular investor based upon the investor's, financial status and risk status and so on. So this whole note is 1022, which everyone should have, attached to their compliance manual or WSPs. It gives a lot of guidance on how to handle, these suitability requirements. And they're saying that, at a minimum, the things you want to look at, when you're looking at the deal itself, at the security, the issuer, its history, its management, the business prospects of the issuer, the assets held or to be acquired by the issuer, representations and forecasts and claims that are being made, and the use of the proceeds, and whether or not it meets an exemption. So, and they remind you also, again, that this should be done with regard to each offering. Even though, you might have multiple offerings from the same issuer where you're building a confidence level and some familiarity. So a lot of this has to be tailored, to I think, the experience level of your investor. Are they accredited or not? There's always a lot of factors here. But there's certainly a minimum threshold. What level, how much investigation, how deep do you dig, how much is required? If you're a broker-dealer you're not the lead placement agent, you're a member of a syndicate, can you just rely on the lead? It all varies. It all, as you know, is very facts and circumstances. But, there's really no particular answer, but I think it's important to point out that a broker-dealer shouldn't rely without some investigation on information provided, by the company or its advisors or the lead placement. Clearly, you should be looking for red flags. Maybe the smaller the company or the newer the company in terms of its life, the deeper the investigation needs to go. Maybe that seems to make sense. If you feel as though you've done some due diligence and you're willing to have it on your platform, or maybe even but you haven't been able to do all the due diligence you want, you should at least disclose the investor, that you've done limited due diligence, that you haven't been able to fully ascertain everything. There's some risk involved. You have to make that disclosure that you might lack certain information. And clearly, even though I think you tailor your, what you're doing to the level of experience or sophistication of your investors, the fact that you have a sophisticated investor, it doesn't totally erase the need to do something. It just might be a question of degree. So, and you want to keep records. Broker-dealers should keep, some records of the process. We'll talk about that a little later. I mean, there's some arguments pro and con on how much documentation you should keep and how that relates to your compliance procedures and your WSPs and what have you. But clearly, your investigation is going to be tailored in such a way that you feel like you're meeting at least your minimum responsibilities, and it kind of makes sense in light of the issuer. So, and there's a lot of guidance in the notice on FINRA in 1022. They give you a list of the practices that might help you discharge these responsibilities. We'll talk about that in a minute. So FINRA also points out, by the way, that reasonable investigation, that the duty of conducting a reasonable investigation is maybe not quite the same as the inquiry one makes under the anti-fraud provisions. There's a distinction there to be made. So there's a lot to think about. Then there's a lot of special issues as well, like if the broker-dealer is affiliated with the issuer. Is it a proprietary product? So certainly you don't want to comprise, you need some sort of independent due diligence investigation there so you're not conflicted. You don't want to compromise, the independence there. What about if the broker-dealer helped prepare the private placement memo? A lot of times issuers have their own counsel. Sometimes a really young, emerging issuer just out there, making it, raising its first rounds of capital. They might look at the broker-dealer and say, hey, can you do this for me? So when you prepare a PPM, you have a duty, that clearly changes your responsibility, I think, in terms of, I think it heightens your due diligence requirement. And if you're assisting in the preparation here, you should think about it not only in terms of due diligence, but this would also be, a communication, it would be advertising. You want to look for red flags. What kind of financials are there? What's the history of the management? Are you asking questions and not getting answers? I think it's the refusal to get a document when you're conducting due diligence, or if a law firm is conducting due diligence of an issuer or a broker-dealer, or the broker-dealer is conducting due diligence. Just the refusal or the delay in getting information in itself could be a little bit of a red flag. Then again, as I mentioned before, just thinking about, relying on counsel and, syndicate members. A lot of times, broker-dealers turn to their accountants and their lawyers and say, be my expert. I want you to handle this due diligence for me. And they can. They can help fulfill a lot of these responsibilities. But this doesn't necessarily, I don't believe, take the broker-dealer off the hook. If the counsels or, legal counsel or counsel might find more issues that the broker-dealer has to find. The broker-dealer might be relying on a lead, but there's still a certain minimum level of effort that must be undertaken. So I think you have to balance all these factors, how to use all these different tools. And obviously this is an area of enforcement. I mean, the SEC does bring enforcement actions on due diligence. I think and they just announced in their, activities for 2019, this is an area of heightened concern, for them, the private placement memos. So some of the other things that fall out of 1022, I think are some of the language that I found interesting. Broker-dealers are not expected to have the same knowledge as an issuer or its management. But even so, broker-dealers are required to exercise a high degree of care in investigating and independently verifying the representations and claims that are made. And again, when you lack essential information, that should be a disclosure item. Affiliated, when a broker-dealer is affiliated with the issuer, they say in the guidance, a BD that is an affiliate of an issuer in a Reg D offering must ensure that its affiliation does not compromise its independence. The broker-dealer must resolve any conflict of interest that could impair its ability to conduct a thorough and independent investigation. Indeed, its affiliation with the issuer typically would raise expectations by its customers, particularly some retail customers, that the BD has special expertise. Now, and again, I already pointed out, red flags, reliance on counsel, maybe that the size, the amount and nature of the investigation might depend upon the relationship that you have with the issuer or the size of the issuer. when an issuer is seeking to finance a speculative venture, FINRA says broker-dealers, quote, must be particularly careful in verifying the issuer's obviously self-serving statements. And again, the fact that you have sophisticated customers or they're knowledgeable doesn't take away your duty to really investigate and get to the bottom of these claims. In Reg D offerings, the SEC advises issuers to provide the same information to accredited investors as they are required to provide to non-accredited investors in view of the anti-fraud provisions. Now, documentation. They say in 1022, to demonstrate that it has performed a reasonable investigation, a broker-dealer should retain records documenting both the process and results of its investigation. Such records might include descriptions of the meetings that were conducted in the course of the investigation, including meetings with the issuer or other parties, the tasks performed, the documents and other information reviewed, the results of such review, the date, who attended, who conducted the meetings, who conducted the reviews. Now, there's a good debate on documentation. I'm of the view that the more the better, provided that it's accurate, provided that the documentation shows what you did and that it was that it was congruent and kind of followed what you have in your compliance manuals and WSPs. I think that's really, really helpful as compared to coming up scant. I think the concern here is that you're giving a roadmap to plaintiff's counsel or to a regulator when you have heavy checklists or heavy procedures. If you don't follow them to a T, you're giving a lot of people a chance to poke at you. So I think having a good set of processes and procedures that are flexible enough to point you in the right direction and make sure that you proceed in a robust fashion and you keep good notes is fine as long as you do it. That's the big danger, having a policy or procedure and not living up to it. That's really, I think, the lesson to be learned from documentation. If you have a process or procedure, make sure you do it, and one way to make sure that you've completed it is to document it. There's another school of thought that says too much documentation, you're just kind of creating a roadmap for yourself. And again, a lot of things, I think permeating the entire discussion here, there's also the concept of what's material, and that's a webinar of its own. What is material in the eyes of the securities law? But clearly, items that that relate to management or finance or going concern, valuations, industry, what's happening in in the industry prospects for the deal. They need to be things that gain some purchase, that have some traction. Now, there is a little bit of a liability issue, just as a back point. So, on private offerings, I said before that, the 33 Act, Section 12 imposes liability in public offerings. And a lot of courts have said that they think it applies to private as well. But the Supreme Court back in 1995 said that 12A2 type relief doesn't extend to a private sale because it was not an offer involving a prospectus, if you will, as that term is used in the 33 Act. So, it may well be that I think the result here is that certain remedies, 12A2 remedies and exposure is available for sales that are exempt under Section 3 of the Act, but not necessarily not offerings exempt under 4 because there's no prospectus there. So those are just some little fine tunings. The Gustafson case is a case that should be looked at. Here's a few more slides I have here that some of the things we just talked about. That'll be good for your notes. Now, one of the things I want to ask everyone to remember is that I'm assuming that you have well-developed processes and procedures in your compliance manuals and WSPs. I think it's really, really important to have those, not only for suitability here, for
for clients, but for, for due diligence. And what I've seen a lot of boilerplate in these manuals and things, which is fine. But you need to have enough. If you have just a lot of boilerplate that doesn't make sense, you're going to be stuck to it. You need to have some flexibility in the way you draft your processes and procedures and your compliance manuals and so on, so you're not necessarily bound to apply the same checklist, if you will, to every transaction. Because I think we've already agreed that every deal is different, every broker-dealer is different, the issuers are different, the industries are different, the investors are different. You need to be nimble and have some flexibility as to how you're working with different people. Again, here in terms of reasonable practices, what are some of the things that you're going to be looking for? Well, clearly, you're going to be looking, for governing documents, financials. What's your past history on securities litigation? You want to talk about the historical financials, trends that you might see in the financials. Maybe you want to talk to customers and suppliers that know the issuer. You want to look at their, applicable contracts or leases or financing arrangements. Look internally at employment agreements and stock options, see what the motivations are for the company. We have some fairly extensive checklists here at Wagner. We don't use them for every deal. There's kind of an internal non-binding tool. We adapt one, we adapt them for each deal that we look on. Business process X. So not only the issuer and the issuer's history and management and so on, but you want to look at the prospects. Is it a good deal? What does the industry look like? What is the idea? Is it patentable? Is it proprietary? Has it been tested financially? How mature is the company? These are all the things that you're looking at. You want to look at patent and intellectual property rights, status of the industry. Really look at the business plans, financial models. And when you're doing due diligence, I don't know that as the counsel helping a broker-dealer or the broker-dealer that you necessarily are rewriting these business plans and financials. I just think, we were all experienced enough in the legal and financial and securities industry so that we should be able to read it, and it should ring true in terms of showing the effort that was put into it and the degree of sophistication and thoroughness. But I think that we just want to know that it's been properly done. We need to look at the issuer's assets too. I mean, if it involves a piece of real estate, has someone gone out and stood on the real estate that you're going to buy, or are we going to build a building? Have you visited and inspected, the assets and facilities to see if they correlate to what you're seeing in the financial statements and what the management is telling you about, the assets? Is it accurate? Any environmental issues or land use issues or engineering type issues that are red flags? Anything from, engineers or other people in terms of the suitability of this investment prior to recommending it, to investors? There's a lot of things to think about. Now, again, remember, so you have, I think there's a supervisory responsibility that's baked on top of the due diligence. You have to conduct due diligence of the issuer kind of, on an objective basis. Is this a deal that we want to bring to the market? Then customer, client specific basis. Is this deal suitable for my investor? How do I look at my due diligence in that light? I have to think about advertising and anti-fraud considerations, all the other rules. But how do I know this is all happening? I mean, there's a supervisory responsibility here as well. So any firm that engages in a Reg D offering has to have supervisory procedures to make sure that the policies and procedures are being implemented and that people are being trained. So you always want to make sure that the firm and your reps in the field are actually, not only do we have a policy that says you can ask questions, but they actually are engaged in an inquiry that is rigorous, thorough, and that it complies with legal and regulatory requirements, that you're addressing suitability analysis requirements, that customers are eligible for anything that comes up under Reg D. You want to make sure that you're not violating the anti-fraud provisions. You need to have procedures in place that look after all this stuff, the anti-fraud provisions. That would mean, anything involving the preparation, distribution of the offering documents, sales literature. All these things must be reasonably designed to ensure that every Reg D offering is supervised before it's marketed to other firms or, sold directly to customers. So there's kind of a layering here. You have your core due diligence that we've been talking about today, due diligence of the issuer and the deal, then the related due diligence for how that fits, for suitability. Then the layered over that is all the supervisory responsibilities, anti-fraud responsibilities, the need for documentation, supervision, training, and so on. It kind of grows, once you get going. Talk just a little more about counsel, because as counsel we are often asked to assist in due diligence or review a firm's due diligence, and we scope our engagement with every for every particular deal. So it's fine. A broker dealer can retain counsel or other experts to assist the firm in undertaking and fulfilling its investigation obligations. I think a BD has to really review the qualifications and the competency of the law firm or the accounting firm or the experts that it retains, and perform a good investigation on its own, to perform an investigation on its behalf, and ensure that any gaps or omissions in the investigation are separately addressed by the broker-dealer. In other words, if you're bringing in an expert or law firm for some limited purpose, you have to make sure that the gaps are properly identified and understood. And here, again, even the use of counsel or experts, remember, this doesn't necessarily, complete the broker-dealer's investigation responsibilities. Insofar as a review of the counsel's report, it might identify issues or concerns that require more investigation by the broker-dealer. It might be appropriate in a Reg D offering where a broker-dealer is merely a member of a syndicate or a selling group to rely upon reasonable investigation by the manager or the lead, provided that the broker-dealer has reason to believe that the syndicate manager has the expertise and is conflict-free, and that it can engage in a thorough and independent inquiry, and that it has in fact performed such an inquiry with respect to this particular Reg D offering. So any broker-dealer that tends to rely upon the syndicate manager, you should meet with the manager, know the manager, get a description of their efforts, and ask some questions considering their independence and the thoroughness. And a broker-dealer that relies upon the efforts of a syndicate manager or a lead, retains its own responsibilities nonetheless, to the extent that they're not addressed by the syndicate manager. So if there's a reason to believe that the manager hasn't addressed something in particular, then each broker-dealer participating, I think, would be responsible to the extent that it thus implicates your own, analysis, on a going forward basis. Documentation. So we talked a little bit before about keeping good notes. Again, I think you want to demonstrate that you performed a reasonable investigation. You have to have some records. Some people think more or less, but the records, should show not only the process, that you undertook, but the results of the investigation. Keep track of who you met with, when you met with them, meetings, notes, red flags, things like that. And again, the big debate here is simply around is too much documentation a trap, to the extent that you provided a roadmap for a regulator or a plaintiff's counsel to somehow come in and pick you apart. I lean toward the side of more rather than less documentation, provided that it's done carefully and that the documentation is robust enough to meet whatever criteria are set forth in your operating manuals and procedures. So there we have it. Private placements are getting very popular. We're seeing more and more of them all the time. Younger, emerging broker-dealer firms are adding them to the retinue of products that they provide. Other old-hand broker-dealer firms are continuing to do it, but it's worth kind of reviewing how you go about your diligence in regard to scrutinizing and assessing these deals. What's your level of inquiry? What's your due diligence? What kind of questions are you asking? How does this mirror your internal compliance policies and procedures and training? How does it relate to your documentation? You want to make sure you have adequate and flexible procedures that allow for due diligence and training personnel and keeping documentation. And I'll close just by saying that, yes, this is an enforcement area. The SEC, there are enforcement actions in this area where they come in. Typically, we see fines, fines, censure for inadequate review of a private. It's usually inadequate due diligence, and we see some fines levied, maybe suspension of licensure for a short period of time. So if you have any further questions on anything involving, private placements, how you're handling the due diligence or the exemptions or any other aspects that relate to these exempt securities that you're offering, please give me a call. Let me know any questions on today's webinar. I'd be glad to answer for you. You can reach me here at the Wagner Law Group. And it would be our pleasure to follow up and send you any materials that I mentioned, answer your questions, and provide any further assistance we can. I think we're just over 1 hour, so thank you very much for attending. I hope you found this helpful and informative, and we will look forward to talking to you at our next webinar. Thank you very much.